Welcome everyone to today's webinar, to the Condominium Management Group webinar. The February webinar's focus is on the Condominium Authority, the resources and the obligations of directors. This is part 2 of the February webinar series. It will focus more on the forms, and we'll get into that shortly. I'd like to introduce our guests today. So our guests are, we have Jonathan Wright Jonathan joins us from the law firm of Elia and Associates, Condo Law.
Hi, everyone.
Jonathan practices condo law, and his particular interest and expertise is in commercial and construction litigation in the context of a condominium. I also am joined with Jonathan as a director. He is also a director of CCI Eastern Ontario, and he is the co-chair of the Education Committee as well. Welcome, Jonathan. We also have Jay Joseph today. Jay is an integral part and a lead of our resource compliance team at CMG. He has assisted over the years in developing the scope of the department's mandate to provide support to both CMG managers and the portfolios that they manage. His focus is on the mandated forms, information certificates, as well as CAO returns and director training. You might recognize Jay from some of your owners' meetings, because Jay has also hosted many owners' meetings, AGMs as well, and he has his hands in many services at CMG, including the CMG virtual meetings, of course, CMG Connect, and he's in the process of obtaining his limited license with the intention of also managing condos in the future. Welcome, Jay.
Thank you so much for having me, Shelley. Thank you.
So let's just jump right into it. I will just put our slideshow up here, and okay, so it should see our slideshow now. Thank you. Okay. So again, we'll just jump right into this. Again, welcome, gentlemen, this afternoon for joining. And this is a continuation of our session that we had last week. So last week we had representatives from the Condominium Authority of Ontario, the CAO, and the focus was on the director training, some of the common issues, as well as they touched on CAT, and how some of the features that they have, including the app that is on the CAO website as well. Today's focus will be on the mandated forms, and we won't be going through particularly all the details of the forms. They're quite detailed, but we'll be focusing on a few different forms and using some examples as far as what directors should be aware of as well. So let's just jump right into it. There are quite a few different forms, and Jay, I'm going to ask you to chime in on this one if you can, please.
Thank you, Shelley. Yeah, so from 2017, the CAO was formed, and that's when all condo corporations in Ontario come under CAO, and there are almost 19 mandatory forms, and I'm sure the board members see them every year for various use. Some of those common forms are obviously the AGM forms and the periodic information certificate forms, which are circulated frequently with the owners. Now, when it comes to these forms, they're all available on the CAO's website, and they're updated quite often by CAO. In terms of deadlines, we will go through them on a separate slide. We will talk some of these forms in detail. When it comes to CMG's role in these forms towards the corporations we manage, CMG has a dedicated team of 6 to 7 resource and compliance administrators who work on these forms and provide them to the managers, which in turn goes back to the board and the owners. Our team has a specific portfolio. So each administrator has a portfolio of managers and corporations they manage. Each of these administrators maintain a yearly schedule for all these corporations and ensure that the corporations meet these specific deadlines and are compliant with the CAO when it comes to information that we provide on the website. Now, I want to slightly talk about, So as the CAO administrators, perform these tasks, simultaneously, they also ensure that the CAO's registry is up to date with all the condo corporation's information. The CAO administrators in CMG also perform the annual returns on behalf of these condo corporations, and they take care of the invoicing and the payment process as well. Thank you. All right, so starting to talk about one of the documents that goes out to the owners on a regular basis. This is the periodic information certificate. It is one of the 3 information certificates that goes out to the condo owners. Now, the periodic information certificate is issued on the 1st and the 3rd quarter of each fiscal year. So just to give you an example, if your condo corporation's year end is December 31st, your first quarter falls on March 31st, and the periodic information certificate has a deadline of 60 days. So the deadline for this certificate to be shared with the owners is May 31st. Now, the CAO administrators usually draft these documents on behalf of the property manager and the board. They make sure all the necessary information is added onto these forms. They ensure the board members' information, the insurance deductibles information, and a lot of financial data is also added in. They make sure all the information is accurate and then send that over to the property manager for their review with the board. And once it's all approved, that comes back to the administrator and they send it out to all the owners. We want to just look a little bit more into the financial aspect of the periodic information certificate. All right, so basically you're looking at a snapshot of page 2 of the information certificate, which gives you detailed information about the condo corporation's financial position as of that specific quarter. So, if this pick is being drafted for the first quarter information, that is the information you are seeing on the financial aspects. Now, the pick is drafted in coordination with the property manager. So the administrators come up with all the basic information out of the financial statements that they have access to. And obviously the manager comes up with all the anticipated reserve fund expenditures and any changes or corrections that need to be made based on their discussion with the board or their own knowledge of the condo corporation. There are a few mandatory attachments that go out with a periodic information certificate, like a copy of the insurance certificate and a copy of the operating budget. As an addition, the administrator also adds a cover letter to the periodic information certificate. Now, if you just look at the certificate, it looks very technical, although it's not, it definitely looks very technical. So adding a cover letter, giving a brief description of what to expect on the pages coming forward, that really helps the owners to understand what this document is all about and what to expect on the coming pages. Now, when it comes to the legal aspect, I want to have Jonathan talk a little bit about that.
Thanks, Jane. Just when you mentioned there that you include a cover letter, I think that's a fantastic idea. When you look at the legal actions relating to the corporation section, there can be quite a lot of scary information there, a lot of big numbers. And if you've just bought into the corporation, or you maybe don't have a working knowledge of how claims, etc., are structured, there can be a lot of eyebrow raising and maybe panic in some respects. But the PIC requires you to outline and to describe in accordance with the mandatory section, the legal actions that relating to the corporation. Starting with the first part, if the corporation's being sued or it's suing somebody, they're a party to a legal action. You're then required to describe the style of cause and the case name and the status. The most common cause for concern is outlined in the total amount claimed against the corporation. If you think of a slip and fall, for example, somebody slipped on the sidewalk, corporation's responsible for snow removal. They may have contractors who are ultimately responsible for it. If a personal injury lawyer has sued the corporation for $5 million because the lawyer is not sure what the actual damages are, maybe there's a large loss of income component, and the lawyer just simply exaggerated the claim to make sure he's covered everything. So you've got $5 million claim against the condo corp. The next section requires the condo corp to outline if it's an insured claim or if there's a policy of insurance that responds to the corporation, or if it's not. And that can be dicey at times because you may have portions of a claim that are covered by a policy of insurance. You may have claims that are outside of the deductible. Potentially, if the court awarded $5 million and your insurance policy covers $2 million, you might have $2 million of coverage, but not for the remaining $3 million. So a cover letter, as Jay just said, there would be a fantastic way of outlining to the unit owner what has happened, and maybe to explain that the condominium corporation has defended the claim by its insurer through its insurance company, and that the claim is working its way through the courts, and just a simple explanation as to what happened. And some people like to do a little bit more digging, and they want to know more information, and that the claim, if it's a claim that's been issued in the superior court and not, for example, by way of arbitration, then the claim can be viewed by anybody. It's a part of a public record, and sometimes if it's a particularly controversial claim, we'll actually advise that people can reach out to property management and obtain a copy of the statement of claim and statement of defense. I think that's all I have to say on that section.
We do have a question that's in the Q&A that either of you gentlemen can chime in on, as far as, and it touches on the financial section here. We've listed out some of the expenditures as far as the reserve funding goes. And the question is does the list of expenditures need to be exactly the same as those that are in the reserve fund study?
I can answer that, Shelley, if you don't mind.
Okay, thank you.
I don't think so. I think the reserve fund study is it's a projection of your potential cost going forward. If you have, for example, an unexpected repair or maintenance project that needs undertaken on an urgent basis, that may have been forecasted for 5, 6, 7 years out through the reserve fund study, but you've incurred those costs, and then you have to describe them in accordance with the PIC.
Perfect, thank you. And sometimes when we're drafting the PIC, it'll vary depending on if it's the first quarter or the third quarter. If it's the first quarter, you're really using the reserve fund study as your guideline moving forward in the year. And then if it's the third quarter, like Jonathan said, you have to look at what the actual expenditures are. So it might vary. Okay, moving right along, we have the information certificate update, Jay.
Thanks, Shelley. Yeah, so this is another mandatory document that goes out to the owners, and very similar to the periodic information certificate, but a little more narrowed down to changes that have happened to the corporation between the two periodic information certificates. So obviously there are around 8 categories that, the CAO provides us guidelines for. In case there are changes to any one or two of these, topics, the owners should be communicated with those specific changes. Like if there are changes to the board members, if there are changes to the insurance deductibles, or even if there's a change of property manager or address of service. So those are some of the things that must be notified to the owners. The usual deadline for an information certificate update is 30 days. And that only changes to 5 days when there's a loss of quorum on the board. obviously, like the minute there's the loss of quorum, everything is expedited, and the manager wants to call an immediate meeting of owners. So the deadline for a loss of quorum is 5 days, and for the rest of the topics is 30 days.
All right, thank you, Jay. Moving along to the new owner information certificate.
All right, this is the third of the information certificate that goes out to the owners. This is, as the name suggests itself, it's a new owner information certificate. As an owner, as somebody buys a unit in a condo, the corporation is required to send them this form with the latest periodic information certificate that went out to the owners and any corresponding information certificate update that went out to the owners. Those are two mandatory attachments to a new owner information certificate. Again, when a CMG administrator does this task, they add a cover letter to the new owner information certificate telling them what this document is all about and what the attachments talk about in detail. As a bonus, we also throw in any kind of forms that we don't see on our files. So let us say if an owner is not signed for electronic communication, the admin would just throw in that form. If we don't have the owner's contact information, we request for that as well. We also nudge the owners if they're not set up for pre-authorized debit. We nudge them to do that for their condo fees. Now, when it comes to the new owner information certificate, there is scope for the board members to jump in here and add any kind of welcome letter that they want to send to the new owner. This can be a sort of a welcome package to that new owner as well. And if there are specific rules and regulations that that the board members want to share, or if the property manager has specific contact information that they want to provide to this new owner, that can be thrown in here as well.
So typically, Jay, do board members see the new owner information certificate before it is issued?
No, this is sent out directly by the CMG administrator. It's basically, the attachments are basically already approved by the board previously, the periodic information certificate and the information certificate update. So, the administrator would just send out those copies without any approval. And
Perfect.
yeah, the deadline for a NOIC is 30 days.
Perfect. Thank you very much. And so if your property manager or condominium manager can also provide you with, a summary of new owners that have where ownership has changed, and we have sent out the new owner information certificate as well. So moving right along, we have, of course, there's quite a few forms associated with the meetings and the voting. So actually, Jonathan, maybe I'll ask you to take over here. If you could just, we won't go through them in all in detail, but definitely they are important.
Yeah, they can be important. To give you a bit of a sort of real world example, sometimes we'll get calls from property managers saying, this hasn't happened or this hasn't happened with respect to notices of meeting or preliminary notices of meeting. And I'm involved in one particular matter, which is ongoing as we speak, that really speaks to the level of confusion, cost, and just general disarray that can happen when even a small mistake is made with a preliminary notice of meeting or a notice of meeting. So in this particular example, there was a condominium corporation that had some structural issues. I don't need to go into the details because it's still ongoing. The board tries to repair the structural issues. The unit owners say, no, you're not doing that. We've had these particular structural things in place for, in some cases, 30 years. And to fix your structural issues, you say you need to take these things away from us. And that's not going to happen. We're not going to let that happen. So what happens is the unit owners and say, well, we don't like the current board and what they're trying to do. We're going to try and replace the board. They serve a requisition to hold a meeting and to replace the board and to give you some sort of ground rules to what happens whenever acquisition is received. You receive and review the requisition as the board. Within 5 days of that, you send the preliminary notice to all unit owners, at least 15 days before issuing a final notice. Then after the preliminary notice is going out, you have to send the actual meeting notice, and the board must send that notice of meeting to the owners at least 15 days before the day of the meeting. You can follow the time frame. Then the notice must contain certain things: the location, date, and time of the meeting, the business to be presented at the meeting, copies of the requisition, and a copy of any proposed changes. So in this particular case, it's a meeting to replace the board, or to vote on the replacement of the board. What had happened in the preliminary notice, in the notice of meeting, is that there was a very small error. The time frame for the so when you say you're electing directors, you have to list the directors that you want to replace and to include the time frames they have left. So your term, or what you're electing. So we're electing a director until the 2014 AGM or 2024 AGM. We're electing a director until the 2025 AGM, that type of information. In this particular case, the notice and the pre-notice listed the wrong timeframes or the wrong terms for the directors. So the condominium corporation took independent legal advice from an independent chair who was asked to chair the meeting. The independent chair said the preliminary notice is wrong and the actual notice of meeting is wrong. To cure the error, you need to have all unit owners, not all unit owners in attendance, but all unit owners vote to cure the error. And if they can't, the meeting is never held because the meeting notice is improper and you need to recall the meeting. Needless to say, the requisitionists were not happy that the chair took this position, and the chair's decision being final, that the meeting was then, well, it never happened, but to say that it was adjourned to another date would be fair. The condominium corporation then tries to schedule a new meeting. The requisitionists say, we're not going to come to your meeting. Under section 46 of the Act, we have the ability to hold a meeting. We have the ability to call the meeting and to charge the corporation back essentially for the cost of having to call that meeting. The problem being that the requisitionists now rely on the previously sent erroneous preliminary notice. Everybody's up in arms. Nobody's sure really what's happening. We have one set of lawyers that's saying, you can't rely on this notice. It's entirely wrong. The other lawyer saying, you're a mistake. We're relying on your mistake. You can't hold us accountable for your mistake. We're going ahead with this. We have the votes. We're replacing the board. All in the background to work having to be done to the structural components of the condominium corporation, the town condominium corporation. And there's just really a large amount of cost being spent on this, a large amount of lost sleep, a large amount of uncertainty, all because a very small component, arguably a small component of the notice that was sent and filled in by the property manager was filled in incorrectly. Seems a lot to do with, seems a lot of work over a very small issue. But we have people that maybe aren't understanding the potential legal implications of this and seeing it as a very personal attack. So when we're asked the question, if there's even a small error on the form, what do we do? Our advice generally will be to reissue the notice and recall them and notify all unit owners, open and transparent communication, recall the meeting for a different date, or to have an independent chair sit in and to administer and chair that particular meeting. There are ways to deal with it, as I mentioned, for example, the motion at the opening to correct the notice. But all that goes to say that can be very costly and expensive for small notices or for small errors in the meeting. There was a question earlier on one of the slides that's in what's the board's responsibility for these forms. Generally speaking, most of the forms, other than those forms which are really just sending out information that's already been sent out, should be reviewed by the board. The board is responsible in nearly all circumstances for the information that's on those forms. The property manager may ultimately be responsible, but not in the first instance. It's a condo corporation that's bound by, for example, status certificates, not the property manager. And there are cases out there, one particular one, in the case of OR and MTCC 1056, where a small mistake in a status certificate cost almost $1 million in legal fees between the parties. Again, the condo corporation was responsible initially. It had to sue the property manager to get the money back. So board members are responsible, and the corporation is responsible for the contents of the certificates. Yeah, do you have anything to add at all, or Shelley?
No, other than to make sure to review these notices that go out, ensure the timelines are met for sure.
Yes.
And the devil is in the details. It's if they are contested, it could be a costly issue for sure.
Yeah.
Now, the timeline, we talked about the ICU earlier and the losing quorum, the preliminary notice of meeting. So if you lose quorum, the ICU, as Jay had mentioned, has to go out within 5 days. But where do you stand as far as the preliminary notice going out, then the notice of meeting going out, the timeline, if you have to call a meeting within 30 days?
I think that trying to think of the time frames here. Within 5 days of losing quorum, you send out the ICU to the owners. Within 15 days of losing quorum, you send a general notice calling the meeting of owners to elect directors. So within 30 days of losing quorum, then you must hold the meeting of owners to elect the directors. And then within 30 days of any change to the directors, you have to notify the CAO through the ICU notice of change. It can be complicated once quorum's gone. There's often a lot of confusion as to what's happening. Sometimes quorum is lost en masse when you have, maybe 4 or 5 directors simply saying, we're done with this, we're walking out because there's a particular issue in the community that's causing a lot of hassle. Good thing is that there's a process in the Act, although the time frame is difficult to follow. You 5 days of losing quorum, you get the ICU out. Within 15 days of losing quorum, you get the general notice calling a meeting to elect out, and then within 30 days of losing quorum, then you must hold the meeting to elect the directors.
Perfect. Okay, thank you. That it's a quick timeline and a quick turnaround, but those are the mandated timelines within basically the 30 days of to have an owners meeting. So along with the condo forms with meetings and voting is the ever popular proxy form. So again, we won't go through this in detail because it is we could have a whole session just on the proxy form. But if you could comment, Jonathan, on the proxy form and how it, some of the details that we really have to pay attention to.
Yeah, the proxy form, another one of these controversial forms. Somebody loses an election. A lot of the case law that around surrounding proxies has been generated by individuals that are upset would be an understatement in some cases, but they seek the remedies of the court to overturn the election and to attempt to have themselves appointed to the board of directors. The first thing that really comes out of these cases is the decision of the chair is key. So if there's any controversy or questions with respect to the validity of a proxy form, it should be brought to the chair, who's chairing the meeting, at the earliest possible opportunity, and to allow them to have the final say, at least initially, on what happens. Some issues that we see with the proxy forms, more so when they were done in writing, there was a little bit more scope for, and we'll call it tomfoolery with the proxy forms. But when you look at them, you've got, sometimes there's no signature in the proxy forms. Sometimes the boxes that say, what the proxy is for, whether it's, for quorum only, for procedural votes, whether it's for, any business arriving. Sometimes those boxes aren't ticked. And when it was brought to you in person and you say to the individual, oh, we can't take this proxy, this box isn't filled out, or this isn't filled out, or it's not signed, what would they do? Well, I'll take it to the owner, I'll go out and get it fixed. But they go out into the parking lot or into the hallway, they tick the box and they bring it back 2 minutes later and say, yeah, I spoke to unit 405, here's the form, they fixed it. Well, you have to take it on the face of it. The court said that proxies are presumed to be valid unless proven otherwise. But you have that issue. A lot of that can be dealt with electronically, because you're not putting the form back into the hands of the proxy holder. But the court has also confirmed some other sort of staples, what we call for proxies, and that printing signatures as opposed to signing your signature, if that makes sense, is valid. There's sometimes people can't sign the proxy, maybe elderly, injury, disabled for whatever particular reason. The court has in at least one case said that it's acceptable to print the name on the proxy, as long as the person that can give the proxy is doing that. Other cases where the court has looked at particular instances, YRCC 818 and Krasuski, where there was an allegation that a commercial unit owner had had submitted 33 proxies, one proxy form, 33 units, and the scrutineers had missed them, had missed the proxy, and it should be counted. And the court said no, there was no actual evidence to suggest that the proxy was actually seen by the scrutineers, and that 5 of the 6 scrutineers had said they'd never seen this. Allegations with respect to no initials on the proxy form, and the court again said, well, there's no actual evidence that the proxy form was there. But the court reverted back to the chair's position, and the chair having the final say on the proxy. Other cases I can think of off the top of my head, one particular case where the chair actually tried to reverse his decision after the fact. He apparently reviewed the proxies after the meeting had closed and a decision had been made and directors had been elected. And that was taken back to court, and the court said no, the chair only has the power to decide on the validity of proxies and the outcome of the election during the meeting. Once the meeting is closed, the only way you can revert that or to change that decision is by a judge or by the court doing that. So it's proxies are difficult to sometimes scrutinize. They're presumed to be valid on the face of them, unless you can really prove that there is an issue with respect to the proxy. It has to be accepted. For condominium managers, the CMSA, really speaks to the fact that condominium managers shouldn't be trying to interfere or influence with proxies. It can be a tricky line to walk. I assume I've never had to do it, but certainly we've had some complaints from, again, aggrieved individuals that have been running for election that it was the property manager who was collecting proxies because if the board had changed, it was known that the property manager would be replaced. So there are lessons for property managers, directors, chairs of meetings, etc. The proxy forms are really not to be interfered with, and that they are, again, held to be valid unless can be proven otherwise.
So one of the questions we have is there an instruction sheet to assist owners in completing the proxy form? I have seen an or an instruction sheet in the past, which is just about as confusing as the proxy itself. And so, but it does, in some cases, it does go out with the AGM package. Again, it's a matter of owners reviewing the instruction sheet and the proxy form and then completing it.
Yeah, it's the form itself is. It's a little confusing to look at, but I think the government form, as you have up on the slideshow, Shelley, actually it takes you through it in some detail, maybe not as much as I would like to see, but it in the right hand column it'll explain what it is. So name of proxy giver, the person entitled to vote at the meeting, things like that. The real key areas are what they're voting on, their name, the signature, and dating it. Dating it and time stamping it really becomes important when you're looking at. Some people will change their proxy or they'll give it to somebody else because there's, more information that's come out, things like that. The only way to really validate which is the most current proxy would be to look at the time and date on which it was given. And that's there as well. But if you ever need help filling out the forms, you can contact, unit owners can contact property management to ask, I don't understand what name of proxy giver means, or I don't understand what this is. And they can give information. They just can't really solicit the vote or to vote in a particular way.
And with the virtual meetings and the virtual proxies, and I'm sure that Jay could attest to this as well, that we have been very successful in having owners complete the proxy and submit them, because the virtual proxy is much easier and simplified than the paper format, let's say.
Yeah, absolutely.
So there's another question as well, and it refers back to owners' meetings and interim directors. So does a meeting need to take place with the owner as soon as possible to vote them in, or is it possible to wait until the AGM if this owner has been, for instance, appointed?
In the event that there's a requisition meeting?
No, it just says if the board member were added in the interim. So they didn't lose quorum, I'm assuming, and they've appointed a director.
Yeah, they will stand in place as a director until the next AGM, where it can be a sort of a full election. The only caveat I would add to that is sometimes when, and it happens very, very rarely, but when a board loses quorum, so we take a 5-member board, three resign, and you've got 2 directors, and they appoint 3 more, and they don't realize that that's not the letter of the law, and it's illegal or not in accordance with the statute. But it has happened. In that case, those directors can't be properly voted in. The condominium corporation can't conduct business at a meeting held for any purpose other than to send out the ICU and to hold the general meeting of the owners within 30 days. So if there is quorum on the board and you appoint the director, that director can stand until the next AGM, whether it's 11 months or 11 days, they can do that. But just make sure the quorum is there in the first instance.
Okay, and as far as proxy goes, so in many cases, as you'd mentioned, that the proxy is in many cases provided to the condominium manager. So can the condominium manager have the authority to refuse the proxy without telling the chair, or? I
would put it up to I think of 2 scenarios. One, when where we used to have these meetings in person, and somebody would walk up and there would be a registration desk, and they'd hand over the proxy form, and the property manager would say, "Okay, no, I can't accept this proxy. It's not signed. Unit owner might disappear and never come back." That's one thing. If that's the case, it wasn't a valid proxy to begin with. In instances where there is particular issues with proxies, for example, maybe the property manager is concerned that a proxy holder has no knowledge of the proxy actually being given, for example, or you're unsure of maybe the signature. I would put that to the chair and say to the chair, this proxy is in, while the scrutineers are counting, this proxy is here. We have concerns over it. We'd like you to make a decision on it. That way, the property manager is protecting themselves of any allegations of soliciting proxies or to try and knock out proxies, but you're also putting a record there that can be put in the minutes that the chair can make a decision and can announce, whether there's been and the votes have been counted. We have disqualified, a particular proxy on the basis that X, Y, and Z. It can certainly be one way of dealing with it, and then there's transparency with respect to what's happened. Proxy forms have also, I know we're going to touch on this maybe in the next section, Shelley, but proxy forms have also been the subject of numerous requests for records. Recent case recently saying, where unit owner has again run for election, again not being successful, but they've asked for copies of the unredacted proxies so that they can, one, presumably, see who didn't vote for them, but 2, to really, to go through and audit the electoral results. The CAT has said that you can't get unredacted copies. The condo corporation has the ability and the obviously almost mandatory obligation to redact unit owner information. So you're not going to get unredacted copies of proxies, and this has been the subject of at least 2 or 3 different cases that I can think of. Do you want me to continue on, Shelley, very quickly?
Sure, yeah, go right ahead. We have, I'm just looking at our timing, so you're on a roll. Go right ahead, Jonathan.
I'll be really quick with records requests. Okay. Not that they are quick, they can be laborious at times, I'm sure. Records requests, 30 days to respond to a records request on the mandatory form. It's on the CAO website if anybody's looking for it. But when you have these records requests, one, the condominium corporation, if they're core records, they have to be provided. Some condo corps will try and find ways to not produce the records because they don't like the requester or otherwise. And the board's responsibility really is to ensure that the act is complied with, and that if they're core records or they're even non-core records, that they be provided. Also to maintain unit owner confidentiality if there's board records or corp records that contain information relating to a particular unit, redact that information. Don't give too much information that you're not required to do. Unit 9 doesn't need to know what's going on in Unit 13, whether there's been a complaint about Unit 13, whether Unit 13's made a human rights accommodation request. That information doesn't need to go into anybody else's hands. And certainly the board could be looked at for disclosing that information in the event there is an issue. They can also be a money pit. So there are valid reasons for denying records requests, for turning them down. For example, if there's contemplated or actual litigation surrounding a particular issue that relates to the records request, insurance issues, things like that. But again, if you're declining records requests because of the sort of money pit that they can cause, going to the CAP, retaining legal counsel, ask a lawyer, take a legal opinion at the earliest possible opportunity if there's a records request and you're not sure about whether it should be fulfilled or not. I'll turn it back to you now. I've talked a lot.
There we go. So moving right along, the other forms, we'll just touch on them briefly. Jay, as far as the agreement to receive notices electronically, perhaps you could chime in on that.
Yeah, for sure. So this is the form that allows the owners to receive electronic communication from the condo corporation. So we usually send these out along with the new owner information certificate if we don't have, the owner's form already. So basically owners do sign up for these forms if they prefer to receive electronic communication or not. If, there are owners who do not want electronic communication and want to receive regular mail, and the form allows them to specify that as well. I have seen many board members, constantly request this data from their property manager, to assess the total number of people, who are on electronic communication, which in turn allows the corporation to save some money on printing and postage. So, that is something the board members do promote a lot.
All right, and Jonathan, status certificates, the importance of, and again, too, this is a big topic to touch on briefly, but if you can.
Yeah, it's, I know we've got a few minutes left here looking at the clock, but status certificates, I think the takeaway for status certificates is don't mess with the form. It's a prescribed form. Don't add information that's not necessary to the status certificate. And if you're not sure about something, put, whether it's your property manager, whether it's a board member that fills them out, if you're not sure, don't make bold statements like there were, in one particular case I can think of, it's the OR and the MTC 1056. The director had knowledge that there was changes to the common elements, but for some reason the manager added there were no breaches of the Condo Act, which would be a breach of Section 98 if there's changes to the common elements, which cost hundreds of thousands of dollars in legal fees for everybody. So when you're looking at the status certificate, if you have knowledge, for example, that common expenses may increase, don't say there's no knowledge common expenses will increase. If you have an ongoing investigation into, for example, a building repair or a building envelope repair, which may cost hundreds of thousands of dollars, but the price hasn't been given yet, the total cost hasn't been given yet, contact your lawyer, ask for an opinion on what should go on the status certificate. When the project is contemplated, don't wait until the day before the status certificate has to be issued. If you're in litigation, ask the lawyer that is representing the condo corporation for wording for the status certificate. All of these things can affect the condo corporation if a purchaser relies on the status certificate, buys into the condo corp, and then later on is issued a special assessment for $50,000. I've had one case fairly recently where building envelope repair was contemplated, just the amount hadn't been set in stone, but we knew it was going to be they knew it was going to be a large amount. It didn't go on the status certificate. The unit owner slapped with a special assessment very soon after moving in. It's really important for filling out status certificates that you rely on the information or the legal opinion of your lawyer. If you rely on the legal opinion of a lawyer under Section 37 of the Act, and you perform your duties and you act reasonably and prudently, you're covered, you're protected under the Act. If any lawsuit comes out, you hold up the legal opinion, say, we got this from our lawyers, we relied on this opinion. Status certificates are bind the condo corporation, they don't bind the manager. Manager fills it out, condo corp is still liable. So it may be that your manager has authority under the management agreement to complete the status certificates. The board should still be reviewing the status certificates before they go out. So it's a real minefield, the status certificate. So I could talk for a lot longer on it, but I'll leave it there.
I think it's quite important to note that like you had mentioned, that this is a form that has to be reviewed regularly by the board of directors, and we're issuing them regularly for every condominium corporation, and it should be reviewed on a regular basis by the board of directors. And if the board of directors at any time has a question as to what is included in the status certificate or disclosure statements that will definitely provide a sample of for your particular condominium corporation. Well, I'm just again looking at the clock, and I'd like to thank our speakers today, Jonathan and Jay, for joining in the discussion. This is, again, with so many mandated forms, we could do a whole session on just one particular form. So we just wanted to skim over a few of the highlights of certain forms and some food for thought, and as well as if directors have any particular questions, we are here to address them as well at CMG. Again, thank you very much for joining us today, and please join us for our March session, which will be, the focus will be on meetings with many AGMs coming up shortly this spring. We have virtual meetings, the challenges of proxies, the importance of accurate minutes, and much, much more. Again, thank you everyone for joining today, and have a good rest of your evening, or not evening, afternoon, and take care. Thank you, Jay and Jonathan.
Thank you.
Thank you, Shelley.